Hello. The title of my presentation is What is the proper role of the state as a guardian? My task is to look at a particular situation where a vulnerable adult has been placed for care in a home or institution, and the director of the institution becomes a guardian of the vulnerable adult. Although almost this model is abandoned in the European countries, the situation still exists as a legal opportunity or as a bad practice in a few states. Therefore, it deserves our attention. The contents of my presentation, as it is shown in the screen, is first, I will concentrate on the problem, describing the problem. Then I go quickly through the quick scans. Actually, the whole presentation is based on the research of the quick scans and on some international standards. Then I will discuss the problems around the guardian's role and in our situation, and provide some examples and evidences from the European Court of Human Rights jurisprudence. Then I go to some international standards, and finally we'll discuss what should be the proper role of the state as a guardian. So what is the problem? First of all, I'm not dealing here with the legal capacity, state intervention in the legal capacity of person, assistance to adults to exercise their roles, rights, and the forms of protection and support for the autonomy of persons. Rather, as I said, I'm dealing with a particular situation where the vulnerable adult resides in a care institution for adults or in adults' residence, and the director becomes his or her guardian. Which are the issues of concern arising from such situation? First, this is the role of the institution, which is to provide care. This is what the institution has been created for. And then the role of the guardian, which becomes the role of the institution, to protect the legal rights of the person, which sometimes should be done against the interests of the institution concerned. So there is a conflict of interest in such situations. Then another issue of concern is the independence and impartiality of such a guardian, and then the issue of violation of autonomy and rights of the vulnerable adult placed in such a situation. That the theme of the state as a guardian, we all know, has its grounds in the responsibility of the modern state to provide care to vulnerable adults. It is a particular manifestation of state care is the case where it is provided in institutions, and where institutions take the role of the guardians. As I said, since the guardian's role is to protect the person on the one hand, and on the other to manage the institution and protect its own interests, there is a potential conflict of interest for the guardian, and issues of impartiality, independence also arise. In a situation where a vulnerable person is placed in an institution for care, also many other issues arise, but they are not in the focus of my presentation. For example, one of the major issues is who decides where the person should leave, or a change of residence is necessary. How another issue is how and if the consent of the person is given, who assists or represents the person to give his or her consent. Why do some states still give the legal care to the director, who has the duty of physical care rather, but is also assigned to protect the rights, the legal rights of the person, and to be his or her legal representative. The quick scans actually suggested that there are two clear cases where this situation exists, and these are cases of Bulgaria and Russia. To start with Bulgaria, I would like to give an example taken from a report following the visit of the European Committee for the Prevention of Torture and Inhuman or Degrading Treatment or Punishment, carried out in Bulgaria in 2010, so 11 years ago. That report, among other issues, identify the issue of our concern today. And the report actually says that it should be stressed in this context that one aspect of the role of a guardian is to defend, if necessary, the rights of incapacitated persons vis-a-vis the hosting institution. Obviously, granting guardianship to the very same institution may easily lead to a conflict of interest and compromise the independence and impartiality of the guardian. Therefore, the committee reiterated its recommendation to Bulgarian authorities to strive to find alternative solutions which would better guarantee the independence and impartiality of guardians. Actually, that report follows visits of the representative of that committee to several institutions for care of vulnerable adults in Bulgaria. And as I said, it took place 11 years ago. Since then, based on that report and its recommendations, but also on some judgments of the European Court of Human Rights, Bulgarian authorities started reforms in social care and social services, and the major changes happened in 2016 and 2020, where the law on social assistance was changed, and in the 2020 a new law on social services came into force. Briefly, both laws dealt with the consent of the vulnerable adult for placement in social care institution. So that was the major focus of that reform, but not the guardianship entrusted to the institution itself. The regime of guardianship for adults and children in Bulgaria is one and the same. It remains unchanged. The guardian's role is to take care of the person, but should act also as their legal representative. There is a general rule, as in many other states, that the guardian should live with the person unless important reasons require separate living. And actually living together ensures the provision of care, everyday care for the person under guardianship. There is another opportunity for the guardianship to be entrusted to the care institution in case the guardian cannot live and cannot provide the physical care of the person. And the law actually says that ex lege, a guardian for an adult could be the spouse or a relative or children or close family person. But if in case there are no such persons, the care residence or institution could become a guardian of legally incapacitated person placed there. So this is in general the legal situation and practices in Bulgaria. Very similar, actually, is the situation in Russia, suggested by the quick scans. There we read that fully or partially incapable person placed into a mental hospital or another residential care institution is not appointed an own guardian, but is placed under the institutional guardianship of the institution in question. And this is the biggest problem at the moment regarding guardianship in Russia. So ex lege guardianship assigned to the hosting institution creates numerous problems. Before that, I would like to mention that actually guardianship still remains as a short or quick avenue for the vulnerable adult to care institution. This is how institutionalization of vulnerable adults takes place in some countries. Because the guardianship actually allows the consent of the person for his or her placement to be somehow avoided. But that is why, as I said, many judgments of the European Court of Human Rights actually focus on the lacking consent which is one of the major violation of rights under the European Convention on Human Rights. Here we can refer to the first case was Stanf again versus Bulgaria, a grand chamber judgment. Then we have the judgment of Stanf against Bulgaria, Todorova against Russia, and many others. There are two cases also referred to in the quick scans against Lithuania. So in the case of Stanf, the court said, it seems clear to the court that if the applicant had not been deprived of legal capacity on account of his mental disorder, he would not have been deprived of his liberty. So this is how to say issue of pertaining to the context of our current problem, guardianship of the vested on the institution. But actually, it could explain the problems around the state being legal guardian of incapacitated persons. So what is the remedy of this situation? I see it in sufficient safeguards provided in the law, and the law taking a human rights-based approach to vulnerable adults, and integrating principles of legal protection and guarantees in appointment of guardian clearly in the law. What we learn, what the case of Stanf against Bulgaria actually tells us, mainly the case, the judgment actually finds many violations of rights of Stanf connected to his situation of being put under guardianship. First of all, and I'm not dealing here with this, the court found a violation of Article 3, since the court agreed that in that institution, Mr. Stanf was placed in degrading and situation regarding his everyday life. Also, that placement amounted also to restriction of liberty of the person. Also, there was found a violation under Article 6, no guarantees for fair trial, etc. But I would like here to refer to the partly dissenting opinion of one of the judges, Mrs. Kalogieva. She was about the Bulgarian judge at that time to the court, and actually being Bulgarian, I think allowed her to really focus and to understand the issue of the institution being acting as a guardian of the person placed in that care institution. What this judge said in her dissenting opinion was briefly that this situation created additional violations of the rights of Mr. Stanf, namely his inability to trigger any remedy for the independent protection of his rights and interests. So the guardian, being the institution, actually prevented Mr. Stanf to challenge first of all its incapacitation. Any attempt, she says, to avail himself of such remedies dependent on the initial approval of his guardian, who also acted as the director and representative of the social care institution. So he was not able to challenge at all its situation before the court, because any claim to the court was subject, also conditional to the guardian's approval, and the guardian was the institution. Next, the situation of the institution being the guardian of Mr. Stanf, of the person, actually prevented him to challenge other rights violation. For example, his right under Article 8 of that convention for the respect of his personal life. Actually, that claim was not given sufficient attention by the court, and that is why in the dissenting opinion, that judge criticized the court for not being sensitive enough. Another, and the last point here, is made by this judge, namely the guardian's discretion to block any attempt to take proceedings in court, she says, affected not only the applicant's right of access to court for the purposes of restoration of capacity, but also prevented the institution of any proceeding in pursuit of the applicant's interests and rights, including those protected. So this situation affected the capacity or the interest of an institution to protect the rights and interests of people, of persons placed there, which is actually supposed to be the major role of the institution, to provide care and to protect the adults placed there. My quick research in the scans actually discovers other potential areas of conflict of interest different from the situation where the guardian is the director of institution. But I'm not dealing in depth here with this potential conflict of interest areas because they may appear in our discussion. So, for example, the case where the guardian ex lege is the spouse of or the child of the person, based on the assumption that these persons are best placed to know, to care and respect the rights of the person, of the vulnerable adults. And here I quote a case, a Bulgarian case, where the court upheld the appeal of a mother who did not want the guardianship to be granted to her daughter, with whom they had a bad relationship and who was only interested in keeping her mother's property, which she would eventually inherit. So this case, again, underlines the need for proper legal safeguards when a guardian should be appointed. Another interesting finding in the quick scans, which is slightly different from the issue we are discussing here, is Estonian good practice to appoint a guardian from the among the institutions that are very close to the vulnerable adult. For example, in the quick scans for Estonia, we find that in a situation where a suitable natural person is not found to be appointed as guardian, a legal person, and I put a question mark here, so it's a matter of discussion who that legal person could be, maybe institution, may be appointed with the consent of the adult. Estonia goes further. If a suitable legal person cannot be appointed as a guardian, the rural municipality or city government with which the adult is most closely connected shall be appointed as guardian. So I found this as an interesting good practice, which could be further discussed. So now I would like to go to the end of my short presentation, which actually discusses a very peculiar situation, as I said, found in a few state parties, states, but in search of international legal standards, I would like to mention two. Article 12 of the Convention on the Rights of Persons with Disabilities actually does not speak exactly and particularly on that, but the Article 12 actually provides standards in protecting the capacity, equal legal capacity of persons with mental disabilities. And among those, we see that assistance for the should be provided that is free of conflict of interest and undue influence. So these are principles for the legislator to be followed in changes in the legislation. And in the Council of Europe recommendation and its principles, there are important safeguards that also should be borne in mind when legal reforms in the respective states are undertaken. I selected the principle 8, paramountcy of interests and welfare of the person concerned, where the recommendation says that this principle implies in particular that the choice of any person to represent or assist an incapable adult should be governed primarily by the suitability of that person to safeguard and promote the adult's interests and welfare, And then the principle of for respect for wishes and feelings of the person concerned, which says that, which implies in particular that the wishes of the adult as to the choice of any person to represent or assist him or her should be taken into account, and as far as possible given due respect. This principle also implies that a person representing or assisting an incapable adult should give him or her adequate information whenever this is possible and appropriate, in particular concerning any major decision affecting him or her, so that he or she may express a view. So to conclude, human rights-based approach and legal safeguards should be aimed to prevent conflict of interest, dependence of guardians when actually assigning or nominating or appointing guardians of vulnerable adults. And these safeguards also require a proper procedural guarantees, namely, if not guardianship is if not the guardian is appointed by the court, so there should be a procedure for challenging the decision of administrative body that nominated or appointed the guardian in cases of conflict of interest. Having said that, I invite you to discuss, debate, correct me if I'm wrong, and propose a good solution to the problem when the state becomes non-proper guardian for vulnerable adults or incapacitated adults. Thank you for your attention.